Thank you. Thank you. Please be seated. Thank you for that warm welcome. Dear Governor Rounds, Lieutenant Governor Dugard, members of the legislature, constitutional officers, my fellow justices, circuit court judges, and all citizens of the state of South Dakota. As I begin my third year as Chief Justice of the South Dakota Supreme Court, it is my pleasure to bring you, once again, both an oral and a written report on the state of the judiciary. I am pleased to report to you that the unified judicial system is strong and is working well to meet the challenges that face us. In 1889, the constitutional drafters gave a gift to the citizens of this state. From the day it was signed, our Constitution has provided that any person who does not prevail in a circuit court of this state has a guaranteed right to have his or her case reviewed by all the members of the South Dakota Supreme Court, whether the case involves a traffic ticket all the way to the death penalty. Although it is not well known, that provision is a significant protector of the lives and liberties of those of us fortunate enough to reside in South Dakota. Only a very few states grant to their citizens the absolute right to appeal to their state Supreme Court. In the vast majority of cases, a person either gets to appeal to an intermediate court of appeals, and that may be their court of last resort, while they are limited to asking their state Supreme Court for permission to appeal, and it decides whether it will hear their case. At this point in time, although the docket of the South Dakota Supreme Court is a busy one, we are getting our work done on a prompt basis, and the Supreme Court is current with its caseload. Last year, through the hard work and cooperation of Justices Sabers, Conenkamp, Zinner, and Meyer-Henry, and the able assistance of a fine support staff, we disposed of 449 filings. From time to time, it's been suggested that we create an intermediate court of appeals, or that we allow appeals to be heard by panels of fewer than the full court of 5 justices, or that we require the court's permission to appeal. None of these well-intended suggestions is necessary at this time. It is entirely appropriate to continue the appeals process to the full Supreme Court as a matter of right given to all citizens of this state and those who use our judicial system. We also continue to take the work of the Supreme Court to the public as much as possible. Last March, we held a full term of court consisting of 35 cases at the School of Law at the University of South Dakota. In October, we accepted the invitation of Mount Marty College in Yankton to hold a term of court on its campus. As many as 805 persons attended an oral argument, most of them high school students. Both terms outside of Pierre are annual events which we enjoy and look forward to. As far as we know, ours is the only Supreme Court in the country that regularly holds full terms of court in educational centers outside the capital to enhance student and public access to our judicial process. At the circuit court level, the court that each of you has in your own home counties, the number of criminal filings has remained consistent with past years. The good news is that there was a 7.5% decrease in the number of felony filings brought to the circuit court. However, for fiscal year 2003, 3,605 people appeared in circuit court on petitions alleging them to be victims of domestic abuse and seeking the court's protection from others. This was a 24% increase in protection orders and is in addition to the significant increase over the previous year. Although the increase in domestic protection orders may be partially attributable to an improved accessibility of judicial relief, these figures are still a cause for concern. The courts continue to work with the Department of Social Services to staff domestic violence coordinators in both Sioux Falls and Rapid City. The coordinators assist victims of domestic violence through a time of high emotions that is usually quite difficult. The other area in which there was a significant increase in the workload of the circuit court was in criminal background searches. Requests for background searches from employers, volunteer organizations, the armed forces, and others increased by nearly 17%. At the circuit court level, every 90 days, all 38 judges must file a report with my office that lists any case that has been under consideration for more than 90 days, whatever the reason. It is reassuring to note that for each 90-day reporting period, the number of cases statewide under consideration for more than 90 days is always less than half a dozen. However, I have never received a notice of a single case under consideration for more than a second 90-day period. The work of the circuit and magistrate courts is vitally important to the resolution of legal disputes and criminal charges in this state. In over 99% of the cases brought before these courts, the decision is not appealed to the South Dakota Supreme Court and thus is final. To most South Dakotans, circuit courts and magistrate courts are the courts that they are most familiar with, either because they have been a party to a case, a witness, or because they have served as a juror. Caseload statistics for your local counties are available in the annual report of the UJS, which is available on our website. We continue to improve and expand the Unified Judicial System's website. Any citizen with Internet capability can access our monthly calendar of cases, which is posted well in advance of our term. In addition, since 2002, in November, the public has been able to access live online streaming of the audio portion of our Supreme Court oral arguments over the Internet. Should it not be possible or even convenient to do so, the arguments are permanently archived for 24-hour-a-day, 7-day-a-week access. Last month, 425 citizens took advantage of this opportunity. When this court issues a decision, it is available on our website within 24 hours of issuance. It used to take weeks for citizens to obtain copies of a decision of this court from a law book publisher that was generally available only to lawyers and then for a fee. Now opinions are promptly available to all citizens at no cost to them. The website currently has 5,800 visits per month by persons viewing our opinions. The website is another manner in which we are educating and informing the public on how our state's judicial system adjudicates legal disputes. Since South Dakota became a state, the Supreme Court has supervised attorneys licensed to practice law in this state, and we take this obligation very, very seriously. The license to practice law is a privilege granted only to those worthy of it. We do not admit to the bar those who do not meet this standard. We remove from its rolls those who commit a serious act of unprofessional conduct when the protection of the public requires such action. In the past few years, we have considered several attorney disciplinary cases. A fair summary would be that within the professional rules, attorneys have a professional obligation to be candid with their client, candid with the judiciary, and candid with each other. Lincoln probably put it best when he advised a young man who was considering the law as a profession to resolve to be an honest person if he could not become an honest lawyer. I am pleased to report that the vast majority of the 1,650 licensed attorneys in South Dakota observe the highest ethical standards of conduct and require no disciplinary action by this court. In 2003, this court reviewed the professional rules that guide attorney conduct. In August, we adopted a completely new and updated set of professional rules which are being considered by most states in this country. While the basics remain largely the same, some areas were modified to keep up with the changing times in which we live and in which attorneys work. For the past several years, the Unified Judicial System has responded to the ever-increasing demands placed upon it with basically the same number of employees. We accomplished this through the dedication and hard work of the 472 full-time personnel in the judicial system. In prior years, we sought additional FTEs for the UJS only when we were convinced that they were essential to our mission. The Supreme Court and the presiding judges are well aware of the fiscal challenges that currently face our state. For the upcoming year, we will be requesting a budget increase of only 0.7% in general fund appropriations and an overall budgetary increase of 0.8%, excluding salary policy and health insurance. We believe this budget will allow us to continue to provide the people of this state with an effective judiciary utilizing the existing number of judges and justices. I would further call to your attention that the judiciary is an instrument of the state that provides revenue to various units of government. In the past fiscal year, we collected $21.1 million as compared to our general fund budget of $25.2 million. Of that $21.1 million we collected, We returned approximately $13.7 million to the counties and the school districts, and $6.6 million to the state, and $800,000 to the cities. Recently, after holding a public hearing to determine the optimum need throughout the state, the Supreme Court transferred a vacant judgeship from the 6th Judicial Circuit to the 7th Judicial Circuit. Governor Janklow appointed A.P. Fuller to that position in Rapid City. In August 2003, Bradley Zell was appointed by Governor Rounds to fill a vacancy in the 2nd Judicial Circuit created by the appointment of Justice Judith Meyer Henry to the Supreme Court. In October 2003, Stephen Jensen was appointed to replace Judge Lee Tappy, who had earlier passed away. Judge Eugene Dauberpool of Aberdeen retired in September 2003 after many decades of distinguished service, leaving a vacancy in the 5th Circuit. Recently, Governor Rounds appointed Scott Myron to fill that position. We wish Judge Dauberpool and Betty many happy years of retirement, and to Judge Dauberpool, on a personal note, many years of full limits of fish and game. For some time, the UJS has struggled to provide adequate judicial services to the areas of the state that have experienced a significant increase in caseloads, an increase that is generally tied to a significant growth in population. At the same time, we have attempted to continue to provide adequate service to the rural areas that are struggling with a declining and aging population. In January 2003, the UJS received a grant from the State Justice Institute to study the issues surrounding judicial services to rural and urban areas of South Dakota. The UJS Planning and Administrative Advisory Council and its predecessor committee, which is composed of judges, court administrators, court service officers, court reporters, and court clerks, had earlier identified the delivery of core court services to the rural areas of South Dakota as worthy of study. Led by this committee, the State Justice Institute funded study focused on the delivery of clerk of court services. Researchers from the Rural Sociology Department at South Dakota State University were hired to survey the public, circuit court clerks, and attorneys practicing in this state. The survey's goal was to identify perspectives on the clerk of court services currently provided, as well as what additional services are needed now and are needed in the future. Although the grant period ended in December 2003, analysis of the information gained from this study will lead the UJS to both long and short-term solutions to the delivery of judicial services. It will also provide a further foundation for research and changes to the delivery system, all with the goal of providing the best possible service to the citizens of South Dakota in the most efficient and effective manner. During the past year, there's been much discussion both in and out of state government about what to do with the problems concerning juvenile justice. I have visited informally with Governor Rounds and with some of you on this subject. The UJS does not pass laws, you legislators do. However, I assure you that the Judiciary stands ready within its constitutional and statutory limits to cooperate with all other units of government. This is not a piecemeal problem, and piecemeal attempts at solutions probably will not work or work as well as a united effort. It is no secret that we in South Dakota are facing a declining birth rate. A couple of years ago, Governor Janklow reported that not a single school district in this state contained as many first graders as seniors in high school. Beyond that, each year a significant number of our youth leave the state and unfortunately do not return. We cannot afford to let those youth who remain slip through the cracks. Borrowing a motto from our President's view on education, juvenile justice should also attempt to see that no one is left behind. In 1995, I was preparing to take office as the Justice of the South Dakota Supreme Court. Behind me were 10 years of prosecuting and another 9 years as a circuit judge. A friend of mine who had been the Roberts County State's Attorney throughout that time stopped by for a visit. We tried to identify a single felony prosecution in Roberts County where the perpetrator had not been intoxicated or under the influence of illegal drugs when the felony was committed, or where the perpetrator was not committing the crime to get money, to get high, or get drugs. In other words, we could not come up with a single felony prosecution during those 19 years where a defendant made a sober decision to support himself or herself by becoming a professional criminal. While this is admittedly anecdotal and possibly unique to my experience, it goes to show the extent to which adult and juvenile criminal activity in this state is tied to substance abuse. In last year's message, I talked about projects that affect adult populations. One of those projects targeted DUI offenders. DUI offenders create a serious community safety issue and contribute significantly to the court's workload. This past year, the UJS, together with the Division of Alcohol and Substance Abuse and the Council on Substance Abuse Directors, studied curriculums that are appropriate to DUI offenders as part of their sentence. They selected a research-based curriculum, and curriculum providers have been completing training in this curriculum. The UJS believes strongly that a utilization of standardized research-based curriculums for first offense DWI offenders is a first step in the long road of reducing DUI offenses. If we can successfully deal with substance abuse, we will reduce crime in this state, especially crimes committed by repeat offenders. Court service operations continue to be an emphasis of the UJS. Senate Bill 202, the Juvenile Justice and Delinquency Act, adopted by the 2003 legislature, is a very significant legislation for the treatment of juveniles. The UJS supports this legislation and will put forth every effort to comply with its 4 key requirements of this act. However, we must recognize that alternatives to jails and secure detention are currently limited by bed space and geography. It is no secret that a major reason for opting out of the JJDP in 1995 was the lack of alternative programs and placement centers in this state's rural areas. It is my sincere hope that as South Dakota adjusts to the JJDP, a full continuum of resources will be developed. To that end, the UJS is developing a centralized intake system for juvenile detention services. The centralized intake system will use centralized sites for intake, a detention risk screen instrument, and a web-based menu for available services. The system will collect data on the utilization of all detention services. Our goal with centralized intakes is to minimize the time it takes to access services for juveniles, link a juvenile to the most appropriate service, and collect the data so that the limited financial resources will be targeted to produce the greatest effect. The project should be operational by the end of the fiscal year. The UJS wishes to thank our project partners, the South Dakota Coalition for Children, who have embraced the vision and committed financial resources to the project. The Interstate Compact on Juveniles, which was established in 1955 and adopted by South Dakota in 1961, addresses the needs of juveniles within the juvenile justice system who move between states. This compact has not been sufficiently amended in its 47-year existence. After exhaustive research and detailed study, the Office of Juvenile Justice and Delinquency and the Council of State Governments formulated recommendations and implemented changes to the compact so that it better addresses public safety, enforcement, accountability, and communication concerns. The UJS will sponsor legislation in 2004 to adopt the new Juvenile Interstate Compact. If 35 states enact this legislation, those 35 states will begin making administrative decisions, bylaws, and rules to govern the signatory states. For many years, court-appointed special advocates, or CASA volunteers, have provided a valuable service to the citizens of this state by appearing in juvenile court proceedings and other matters as friends of the court. The program has been an unqualified success. The 2003 legislature created a Casa Commission, administered and staffed by the UJS to award grants to CASA programs in South Dakota. You created a funding mechanism which is permanent for CASA programs by authorizing a fee to be applied to criminal fines. With these enhancements now in place, we hope for even better results in the future from this fine program. Since the end of the Civil War, this country has attempted to achieve equal protection of the law for all its citizens. While this is a simple concept on the surface, as with other ideas, the devil is in the detail. With the beginning of 2004, the Supreme Court has embarked upon another program to achieve its goal of equal protection for all persons. The Court has created an Equal Justice Commission. It will be co-chaired by Justice John Conenkamp of our court and the Honorable Patrick Lee, a retired tribal judge for the Oglala Sioux tribe. The 11-member commission will conduct a series of public hearings throughout the state. It will then make recommendations to the South Dakota Supreme Court. The commission will be composed of citizens, lawyers, and judges. We hope to have the balance of the commission selected and hearings commence within the next few months. Many fine words have been written about the sanctity of the family home and the home being a person's castle. For all too many people, home is instead a place of fear due to mental, physical, sexual, or emotional abuse. Some acts that are committed in the home verge on depravity. For many years, the crime of domestic abuse, and we should call it that because that's what it is, did not receive the attention it deserves to adequately deal with the problem. Nevertheless, progress, while slow, has been made. When I was a prosecutor and later when I was a circuit judge in my home county, it was apparent that bordering two states, together with a checkerboarded state tribal jurisdiction, created additional challenges for dealing with domestic abuse. A perpetrator often avoided the legal consequences of his or her acts of abuse by simply going to another jurisdiction or state. Recently, when I was visiting with a tribal judge, she identified the inability to enforce domestic protection orders between the tribes and the state of South Dakota as her #1 judicial problem. This past year, the legislature, in cooperation with the governor, the attorney general, and my office, passed what is now SDCL 2510-12.1. This statute allows South Dakota courts to enforce protection orders issued by other states or tribal courts to the same extent as orders issued by a South Dakota court under South Dakota law. In a crisis situation that calls for immediate action, the South Dakota law enforcement officer may now enforce a foreign protection order and make an arrest as though the order was issued by a South Dakota court. Only when domestic tranquility is protected can we successfully move forward and accomplish other worthy goals such as racial, ethnic, and religious toleration and reconciliation. Such lofty goals probably do not mean as much to those who fear for their lives or safety or for family members simply because they return to their homes or a perpetrator or abuser returns. As the United States Supreme Court has said on numerous occasions, the right to be let alone is indeed the beginning of all freedom. While this doctrine applies to many situations, the Court has made clear that this right to be let alone includes the right to live one's life as one chooses, free from assault, intrusion, or invasion. While I'm not naive enough to think that the legislation of this type will resolve the causes of domestic violence and it will cease to exist as a problem in our society, it nevertheless fulfills a basic need provided by governmental protection. As Dr. Martin Luther King wisely noted, it may be true that the law cannot make a man love me, but it can keep him from lynching me, and I think that's pretty important. I predict that this simple piece of legislation that you wisely passed will have a significant positive effect in the future. Thank you for giving law enforcement and the courts this additional tool to assure justice for all. There are many of those who, because of their tender years or other circumstances, are unable to report neglect or domestic abuse inflicted upon them. Since they cannot defend themselves or even leave home, they are often in the most potential danger. The Department of Social Services and law enforcement cannot be everywhere at all times. Citizen involvement is essential. Like the priest and the Levite in the parable of the Good Samaritan, it may be easier to quietly pass by on the other side of the road, but such an attitude does not solve the problem. It only makes the problem worse. To those of you South Dakotans who have come forward to respond to the needs of a disabled adult or the cry of an abused child by reporting it, or who have gone beyond that by going to court with them, testifying as a witness, becoming foster parents, or adopting them, I salute you. The history of Dakota Territory and the state of South Dakota is for the most part not a history of individual persons, be they good, evil, or somewhere in between. In large part, our history is a history of families. That is why this address has in large part dealt with family issues. As I told you last year, South Dakota judges identified the disintegration of the family as their #1 problem. Good families produce more good families. Some do it on their own. Some need help from government, church, schools, and other organizations. Unfortunately, bad families may have a tendency to produce more bad families. As the philosopher Santayana said, those who ignore the lessons of history are doomed to repeat them. He did not exempt domestic relations from this observation. If we are to achieve a positive future for this state, it is our challenge to do so by helping those who are struggling to be good families to achieve this goal. Once again this year, as we discuss the state of the judiciary in South Dakota, American servicemen and servicewomen are in combat conditions, defending our system of government and our way of life. Those who were your paper carriers and your cheerleaders a couple years ago now defend you in combat. In many instances, they are members of your family or my family. It strikes me that when asked why they do it, they do not quote Montesquieu or Locke on the theory of government. Rather, they share the sentiments like those written in a diary on Christmas Day, December 25, 1944, at Lady Island in the Philippines by a young Army nurse. She had been involved in surgery and caring for wounded soldiers under combat conditions for the past 2 years. She wrote from her grim surroundings. Got a letter today from home, which is more welcome than any gift. Do miss them all so much, yet Christmas here is really something I wouldn't miss. Spirit is the important thing after all, and it's here. That lonely but very focused young nurse would later become a mother. She, like the rest of those who served in the armed forces then and now, missed her family greatly, but knew the defense of her family and her country was worth the sacrifice. May God keep those who serve currently safe and return them home to us and their families. Thank you.